Get ready? Start. 10. In the instant appeal, as demonstrated here in above, though the documents, particularly the charge sheet dated 8/6/2013 and the cognizance order dated 16/6/2013, were neither part of pleadings nor were produced during the course of arguments before the High Court, the certificate at the end of the SLP appears to have been given by the advocate on record appearing for the appellant without verifying the facts which were otherwise very apparent from the record. Stop. The affidavit by the husband and perukar of the petitioner Sri Saurabh also appears to have been filed at the bottom of the SLP without verifying the said facts. Stop. Even the affidavit sought to be filed pursuant to the query raised by the court was also not filed answering the query, rather was filed making vague statements. Stop. Though the said charge sheet and the cognizance order were neither pleaded nor argued before the High Court, an impudent attempt was sought to be made by alleging all throughout in the synopsis, list of dates, questions of law and the grounds in the SLP that the High Court had grossly erred in not appreciating the said documents. Stop. Para 11. Having regard to the above state of affairs, the court has a reason to believe that there was a bold attempt made by on behalf of the appellant to misrepresent the facts for challenging the impugned order. Stop. The certificate to be issued by the advocate on record and the affidavit to be filed by or on behalf of the petitioner appellant at the end of the SLP as per the provisions contained in the Supreme Court rules do carry sanctity in the eyes of law. Stop. It is unbelievable that the battery of lawyers appearing for the appellant did not notice the apparent fact that when the charge sheet and cognizance order were not existence before the High Court, when the arguments were concluded and the judgment was reserved, non-consideration of the same by the High Court could not be made the basis for challenging the said order in the SLP before this court. Stop. It can not be gainsaid that every party approaching the court seeking justice is not expected to make full and correct disclosure of material facts, and that every advocate being an officer of the court, though appearing for a particular party, is expected to assist the court fairly in carrying out its function to administer the justice. Stop. It hardly needs to be emphasized that a very high standard of professionalism and legal acumen is expected from the advocates, particularly designated senior advocates appearing in the highest court of the country so that their professionalism may be followed and emulated by the advocates practicing in the high courts and the district courts. Stop. Though it is true that the advocates would settle the pleadings and argue in the courts on instructions given by their clients, however, their duty to diligently verify the facts from the record of the case using their legal acumen for which they are engaged cannot be obviated. Stop. In the instant case, though the court had specifically drawn the attention of all the learned counsels appearing for the appellant with regard to the expressai inconsistencies appearing in the grounds mentioned in the SLP and in the certificate and affidavit filed at the bottom of the SLP as per the order dated 9/10/2013. Again, an attempt sought to be made by filing a smartly drafted affidavit abiding to answer the query raised by the court. Stop.